Ladies and gentlemen, good morning. We're about to start. It is my pleasure to introduce to you this business breakfast organized by Kommersant as part of the St. Petersburg Legal Forum. This has become a rather established tradition to combine discussion and a hearty breakfast. I think you will prefer discussion. I think the title of this business breakfast captures the idea behind this event very well. I'm not going to reiterate the mantra about the window of opportunities that arises from the rather peculiar circumstances that we find ourselves in. However, these circumstances invite new solutions, including solutions in the legal field. It's a fact. So, what about the legal strategies in an era of turbulence? This is the topic of this business breakfast. This discussion is going to proceed as follows. We have a panel of experts around this table, and I'm going to introduce them to you. Each of them is going to make a few introductory remarks rather briefly. After that, we will open discussion, and we'll welcome your contributions from the floor. On your tables, you have these interesting devices that you can use. Fifth channel is for Russian, sixth channel is for English. So let me introduce our speakers today. We're still waiting for two people. We have here Yuri Lyubimov, State Secretary and Deputy Minister of Justice of the Russian Federation, Gadis Gadjiev, who is a judge of the Constitutional Court of the Russian Federation, Mikhail Popov, Director for Legal Affairs, RT Invest Transportation Systems, Yevgeny Sukhanov, Deputy Chair of the Board of Codification, Vitaly Monkevich, President of the Russian Asian Union of Industrialists and Entrepreneurs, and as I said, we're still waiting for two people to join us, Oksana Balayan in particular, who is the managing partner of the Moscow office of Hogan Lovells, and we're also waiting for Konstantin Olefil, who is the head of the legal department of AFK Odkrytie Corporation. I'm now going to turn it over to Yuri Lyubimov, please. Yuri, the floor is yours. Good morning, dear friends. First of all, I would like to say that I'm very happy to see you at this fifth St. Petersburg International Legal Forum, which is celebrating its anniversary this year, 5 years, and this is very important for me because I was at the very beginnings of this forum. It's a very important milestone. The forum has become an established tradition. It has formed a community of people who keep coming here. Different people, but people who are committed to organizing rather interesting events every year. This year, I think we have all experienced the power of this commitment, the power coming from people who are ready to explore new formats, and I would like to thank Kommersant for providing support and for actively contributing to this event, and also for creating this vibrant atmosphere and an opportunity to discuss. This is a very interesting and a very successful opening event of the forum. The topic of this breakfast is formulated in a rather controversial way, I must say. I personally have a morbid fear of flying planes, and I know that turbulence is an event during which the only personal strategy that you can use is to hold on for dear life, possibly looking at the flight attendants and cursing yourself for not having chosen a less antiquated aircraft to fly. So, of course, strategizing is very difficult in times of turbulence. This is why the task we're facing is rather controversial. However, the organizers of this event are right when they say that any turbulent event usually encourages new visions, new horizons, and the search for new solutions. Take the economic aspects, for instance. In any country, the most effective reforms have always been carried out in some very difficult times, because difficulties usually challenge us to reinvent our solutions and to reinvent our thinking. So what we're facing today is a dual task indeed. Task number one is to sustain ourselves through these times of turbulence, but also, secondly, to open up new strategies or to build a new strategy, which we're all invited to discuss here. We know that in our past life, so to speak, we were in a situation of rather challenging competition between legal systems. We know that our legal system has certain shortcomings and it's difficult to compete. However, the situation has become more difficult, and the challenges that we're facing are even more critical today. Because I'm responsible for economic legislation within my ministry, I would like to share with you my perspective as a person who is responsible for various regulations that the ministry registers and deposits. I think I have developed some unique experience in this job, and I'm grateful to my management for it, because I think I have a very broad perspective on our legislation, because any document, any act that becomes part of our legal system will go through my office eventually. So let me share with you some ideas regarding how, in my opinion, we could be moving in order to acquire a competitive position amongst other international jurisdictions. It is a banal thing to say, however, in order to successfully compete in the competition among jurisdictions, one has to create a set of rules that will be maintained for at least a period of time without any changes. Take the train metaphor, for instance. I took the train to come here to St. Petersburg yesterday, trying to avoid turbulence. Yes, turbulence. And I think it was a good strategy for me. It worked well. Because on the train I was able to meet many of this forum's participants, including Yevgeny Sukhanov. Imagine the ticket booking system that you use when you book a ticket to go from Moscow to St. Petersburg on the high-speed Sapsan train. Imagine this train does not stop in St. Petersburg and goes all the way to Arkhangelsk or beyond the polar circle without stopping. If that is the way things operate, this kind of system is not going to be very competitive. I think one alarming challenge that I have observed over the past years is that despite the fact that legislation is supposed to be stable, the tax code should not be amended 500 times in 4 years and so on and so forth, and this is indeed a very valid statement which I share and which I have expressed at various venues. Nevertheless, we have seen this alarming trend of changes and amendments. What has happened over the past years? Many line ministries and departments have been tempted not to address the gaps and deficiencies in the legal system as it exists now, but rather to overhaul it completely by trying to build a perfect system right away. Let me give you a few examples of that. We've had this experience with special economic zones. What is a special economic zone? Yes, there have been very successful practices in a number of countries that we're looking to these days. Nevertheless, by agreeing to establishing special economic zones, we tacitly acknowledge that the legal system is not working everywhere, so we wanted to create a number of places where it would work. And we also decided to create in the Russian Far East a number of advanced economic development areas. We were highly critical when we provided our opinion about that legal proposal by saying that we should not really try to create a new legal regime without addressing gaps in the existing regime. Special regimes have been created with respect to Sochi, Skolkovo, and a number of other places in Russia, including Crimea. This all serves as a testimony to the fact that the government is trying to duplicate its infrastructure for more efficient provision of services. In my opinion, all these situations resemble a situation where you are, for instance, trying to repair your summer house, and you already have a frame, but then you decide to create an entirely difficult structure on the same plot of land, abandoning any repair work in your summer house, and you decide to move to a new place rather than fix the old place. Then we have this second reading problem or disease over the past several years. A lot of reforms are currently being implemented by introducing second reading amendments into bills. Until we depart from this practice, we will not be able to turn the situation around.
Well, yesterday we received a law on bankruptcy, and the third most important problem that we are faced with, which is becoming a chronic phenomenon in our legislation, if we want to compete with any systems where law exists. That's the problem of protecting the pseudo-social interests which exists in this country. We, in the legislation that we adopt, we include a lot of provisions that are intended to protect someone or some groups of population, but at the end of the day, it all leads to increased costs for all the parties involved. The law of land, so we were supposed to say a few introductory remarks, and you have started the discussion already. Could you please be more general? Let us go from the plane to the train and ensure that this train goes according to its timetable to the place where it is supposed to go, not faster or not slower, that the passengers require, with the priority of safety in terms of speed and everything else. Okay, so let us continue this very metaphorical discussion. I would like to thank Yuri Lyubimov for his opening remarks. Well, I would like to say that in the times of turbulence, you can be able to stabilize the plane that is flying, but it is falling down. It is much more difficult to speak. Gadis Gadjiev, I would like to give you the floor now, because you suggested a number of very intriguing topics, like acquisitive law, risks of legal transplantation. I would like to say, first of all, that I agree with the word turbulence, which is part of the title of our discussion, is quite a good choice. We're talking about on images. Law can be very poetic at times, and we understand full well why we're talking about this topic of turbulence, because probably we have exhausted those internal sources that we've been relying upon traditionally, and the dean of the law faculty of Moscow State University says that we are overwhelmed by our natural riches. So we need to overcome this situation of being overwhelmed by our natural riches. And I have, through my experience, come to a very firm conclusion that no economists, no economic stimuli cannot move the economy forward. This is the purview of lawyers. And legal incentives to economic growth are the only incentives that we have. We don't have anything else. I'm not going to say what those incentives or stimuli are, because I don't have time for that. But I would like to say that what I meant when I said that in the current conditions in which we have found ourselves now, we need to introduce legal transplantation, diffusion. Those are very broad concepts. But what happened in 2008 when the crisis started, we started to immediately amend our banking legislation. And of course, out of those trivial credit organizations that are only seeking for profit, those credit organizations now are protecting and safeguarding private and public interests. And what it means legal transplantation. And another concept that seemed to you very intriguing, you know, this is not my invention. But before my yesterday's talk, I took a look at I consulted a Russian Latin dictionary, and I was interested in the word of ars. That is the definition of what law is about, the art of goodness and justice. And I've always came across this definition, but I thought that students don't understand that, why art is involved in all this. But now, 40 years after I graduated, I'm beginning to understand the depth of this insight. I cannot say very clearly what ars is. Ars in Latin has 7 meanings. It means science, it means handicraft, cunningness, deviousness, and evasion of law. So ars was known to Roman lawyers in this sense as well. But exquisiteness of law is they understood, the Romans did, they understood that the law can be exquisite, subtlety of law. And I taught Roman law, but I didn't understand how exquisite it can be. The legal norm is always kind of rough, but in order for it to understand different situations and take into account different situations, it is important to have appropriate case law. Case law is very important. It's much more important than any theories. What should we do to make our law more exquisite from the point of view of case law? Maybe some people here won't agree with me, but I think that the most important thing for our course today is to be brave. This is what they are lacking. They have enough knowledge, but they don't have enough courage when they protect the subtlety, the exquisite nature of law. They should be brave at their discretion. I'm just outlining this topic because I'm looking at my watch and I'm seeing that my time is up, so I will stop at this place. Okay, thank you very much. I haven't introduced myself. I'm Anatoly Kuzichev, general producer from Kommersant FM, and I would like to give the floor now to Evgeny Sukhanov. Okay, everything's working. Will you please, ladies and gentlemen, switch off your phones? I'm speaking as a member of the Council for Codification. It's not just a codification council, codification of everything. We are working in the field of civil law. This is the only purely legal council under the President of the Russian Federation, because the civil law provides the basis for legal regulation of economic and other relations in the society. And from this point of view, I would like to say a few words on the topic of our today's discussion, very briefly. Starting from the Soviet times, we are used to looking for a magic wand, but wherever turbulence is involved, this is a permanent state of our economy. I remember the Soviet times. We studied together with Gadis Gadzhiev, and we were asking our students what are the main features of socialist economists, and someone said temporary difficulties, and we were living in the situation of those temporary difficulties in Soviet times, and afterwards we are going to, if we are going to seek this magic wand, and this search started in Soviet times. Cooperation and leased enterprises, state cooperation, international financial center, where is it? And the legislation was, worsened quite substantially. The territory of accelerated growth, not only in the Far East, but we've been planning to create those areas all over Russia, and our higher public authorities, and I cannot but say it, the public authorities have very ideas, which one of the very famous lawyers said, characterized. Marx said that the ideas become a material force when they become enshrined in the mind of masses. But another lawyer said that these ideas become overriding when they are enshrined in the ruling masses.
But at the end of the day, there will always be temporary difficulties in the form of sanctions or other turbulent events. Life is made of them, and it's impossible to always adjust your legislation to meet these new challenges. And this is why when we are talking about strategies in turbulent times, I think the most important strategy should be to incrementally improve our legislation, civil legislation and legislation for private law, because this is the foundation. We need to have legislation that serves as the basis for all economic activities. Various customs innovations or taxation regulations are secondary. Once you have a solid framework, after that you can add to it prohibitions or certain permissions in the tax or customs field. But first there needs to be a solid basis embedded, enshrined in civil legislation for regulating economic activities. And our civil legislation is still in a form of flux, because it's been 20 years ever since we embarked on the reforms. So it would have been impossible to build a fully market-driven system of civil legislation. It took decades for other countries to develop those frameworks. And this is exactly what we're doing in the codification board. In the codification board, we're taking steps in order to step-by-step improve our civil legislation, primarily the civil code. Many legal experts have heard about the conceptual framework for the development of civil legislation, which informed the development of the new civil code. Some of the elements of the concept have been implemented, some not. There has been a lot of lobbying to counter with. There have been a lot of inputs, controversial inputs from the Ministry of Economic Development. There have been initiatives like the International Financial Center that distorted the picture. Nevertheless, we have been able to put in place a framework for corporate law in the past years, because we didn't have private law before that. We didn't have any regulations or rules for corporations and corporate relations codified in our law. Now, our hope and fingers crossed certainly is to obtain by the end of the year a new set of property-related legislation, because I don't know if you know or not, property legislation, property law is the basis of our life. No matter which system, political system you live under, the land code is derived from that. You cannot have a market economy and I don't want to criticize the previous systems, but you cannot have a market economy if if this is based on outdated legal frameworks. Rather than developing a framework, a systematic framework, people are trying to do a little bit of tinkering and piecemeal efforts aimed at creating special zones or special areas. Instead of that, I think the priority should be to create a solid foundation. The businesses have adjusted themselves already to all these transitions. For instance, take the lease arrangements. A lot of development is happening on the basis of lease today, even though until recently lease agreements could only be made for up to 5 to 10 years. Now it's 40 years, but back in those turbulent times, they used lease to develop, and most of those lands were government-owned, and people were dealing with government officials who had no stake, no interest in developing those lands. These iterative process, this lack of stability generates a lot of corruption. About a week ago, the State Duma held a round table where we were trying to convince large businesses to agree to the law, to the new laws concerning development and property rights, and some of them are reluctant because they have already become accustomed to the old, ever-changing patterns. But this is not the way to go if we want to build a market economy. Of course, we should be leaving some of the old practices in the past, some of the organizational forms such as unitary enterprises. We shouldn't base our future development on some of the old Soviet legal norms, and I think this avenue should be pursued with willingness and courage despite whatever temporary difficulties come under our way. I think this should be the strategic orientation of ours. Okay, Oksana Balayan, managing partner of the Moscow office of Hogan Lovells. I'm giving you 5, 7, say 10 minutes for an introductory presentation. Thank you very much for giving me a lot of time. I believe this is a very interesting and very stimulating topic to discuss. Thank you for coming here. I do hope that in the coming 3 days we are going to have a very enriching discussion. Whenever people talk about strategy, I always think back to my school history classes. We had a bunch of backbenchers in my group, people who were always sitting in the back of the room, and they were using rather in devious ways to cheat on the exams and tests, and this often led to very low, poor marks, poor grades. And the history teacher said, you know, this is your strategy, but sometimes you have to check your assumptions. Is the strategy correct? This is my approach to strategy ever since. Every time I think about strategizing, I usually try to review my strategy after a certain period of time to see how it performs. I think the times we're going through are turbulent indeed, and strategies need to be changed. A lot of things need to be changed, as a matter of fact, in the legal field, the law, case law, the nature of legal businesses should be changed as well. However, this is also an opportunity for us to pursue creative approaches to see what can be changed in a creative way in order to improve the state of affairs. Yes, of course, Yuri Lyubimov is right when he says that there is still a lot of road to cover before we build a solid legal framework, but I think he's being too modest. I remember 20 years ago I encountered him in a university library in Bavaria. I was busy writing my thesis and he was busy preparing a law and parts of the civil code. He was studying some of the old German legal regulations, thousands of pages, a massive work. However, this made me realize that the legal experts, the people who invested their time and effort into creating Russian law, had a lot of experience and a lot of tenacity, and they have certainly contributed all that knowledge and all that expertise to what we now have. I am in the field of practicing law, so I have to use with my clients, with the businesses, some of the businesses are represented here. When we work with them, we use what the lawmakers give us. But we already feel that some of the tools that the lawmakers are giving us are more powerful and more flexible. Take the civil code, for instance. The ongoing changes are truly positive for the businesses. Think of those jokes when a Russian, an American, an Englishman meet in the same room, and everybody will find something interesting for them, for their country. In our civil codes, for instance, the Germans may find some valuable elements. The British, I think, are happy about the option type contracts. I think the US, the Americans should be happy about the good faith provisions that we now have. But of course, the greatest benefit is to be derived by the Russians. Therefore, I think the recent developments, the recent changes have been rather positive. It's only a matter of applying them adequately in the current reality. Thank you very much, Oksana. But shouldn't the joke go that these three people from different countries should start drinking together, right? Okay, let's continue, and I'm now giving the floor to Vitaly Monkevich, President of the Russian Asian Union of Industrialists and Entrepreneurs. By the way, the Asian dimension is gaining significance in these turbulent times, providing new opportunities. Please, Vitaly. Good morning, dear colleagues. Yes, indeed, I represent the Russian Asian Union of Industrialists and Entrepreneurs. And yes, indeed, the Asian dimension is very much demanded today. The Union was created in 2009, right after the crisis broke out, and since that time we have been consistently promoting cooperation between Russia and the Orient, the Asian countries. So we didn't start this trend, it just happened so. And today I think I can agree with my partners, with people who are working in this field, that the Russian Federation is constantly experiencing turbulent times. Russia is yet to find its own way into the future. Even though Russia is an ancient country with established traditions and historical patterns, nevertheless, we have been swaying sideways very often. Yesterday we were friends with Europe and the US, saying that we were friends forever, and that was the only option. Today we're saying that we're looking to China to become our strategic partner for the future. Shouldn't we rather think about our own development? Shouldn't we be rather changing our legislation and developing it so as to benefit from it rather than be harmed by it? Shouldn't we be trying to encourage our own economic agents to develop? Yes, indeed, China is a welcome partner of Russia these days. And I take pride in it because for several years we have been promoting economic cooperation with China, and this is very promising indeed. Nevertheless, I don't think we should be throwing ourselves into the arms of China, because the Chinese partners can be rather tricky indeed. About a month ago, we established a legal alliance between China and Russia. As you know, the Chinese market for legal services is a rather closed one. It's ridden with complexities, so you need to have local people with local knowledge in order to go into that market. I agree with my colleagues when they say that things should develop step by step. And I certainly, with Mr. Yuri Lubimov, when he talks about turbulence when it occurs during a plane flight. I hate flying, but my job takes me to Asia quite often, so I have to take the plane because there are no train services there. This time I came to your city by train, and it was an immense pleasure for me. It's been a while since I took a train last, so thank you very much for inviting me here. So I think it's evident why we should be looking back to Europe. It's much closer. You can reach it by train. Well, I think we should develop Russian wide-bodied jets, establish services to Asia and China, and maintain regular cooperation. Okay, I'm now inviting Mikhail Popov, the Director of Legal Affairs of RT Invest Transportation System, and that brings us back to the topic of transportation. Thank you very much, colleagues. It's a great pleasure for me to see so many familiar faces here. To continue on some of the topics touched by my colleagues, I think Alexander II provided an exhaustive list of our friends and neighbors, but at the end of the day, I believe that the only way to go for us is to foster our legal framework. Despite the skepticism about the idea of an international financial center, I think it was a positive and valuable experience because it has also opened some new horizons. I think we're in for some interesting experiences in the coming years because the part of civil code that is coming into force on Monday about law of obligations will create eventually a lot of case law and a lot of law enforcement and application. As far as turbulence is concerned, I think there should be a dividing line between turbulence and flutter effects. You know, before a plane crosses the sonic boom barrier, it is subject to very heavy loads and heavy vibrations. Once the sonic barrier has been crossed, the plane stabilizes. So some of the turbulence that you think is turbulence is actually flutter, and it can be overcome by simply going an extra mile and making an effort in order to achieve a new level, and by that I mean a new level in our legal development, and you will be in a much better position to add value and create benefits for your companies, for your economic agents and society in general. Thank you very much, Mikhail, and I thank all the panelists. Our first speaker introduced this joke, which has somewhat carried us away, the joke about trains, planes, supersonic aircraft. We no longer have supersonic aircraft, guys, no more Concorde. Last Sunday, Russia marked the anniversary of Brodsky, and Brodsky talks about the correlation that exists between a bullet and the target a lot. And I think this is very true indeed. When we discuss these current problems that we're experiencing, we should not forget about that law. Let us now move on to discussion, and I would now ask Yuri Lubimov to elaborate on his idea of competition between jurisdictions, among jurisdictions. How is that expressed? How does that manifest itself? What is the source of competitive advantage for a jurisdiction? Is it flexibility? Is it stability? And since we're talking about strategies, and we're not taking strategies very broadly, but thinking about particular strategies and steps to take, what is your take on it, Yuri? Okay, thank you very much to turning it back to me. Regarding competition, it is commonly known that the world is becoming increasingly global. Therefore, shopping for jurisdictions is very easy. Today, Russia is not only competing with the traditional legal leaders, Western Europe, some of the largest financial centers around the world. Today, Russia is also competing against its closest members, because some of our closest members have already succeeded in developing high caliber legal frameworks. And sometimes if something is holding us back from taking bolder steps that Oksana talks about, if we are too shy to adopt some of the effective norms for business transactions, if we're too shy, those transactions will go and will be concluded in other jurisdictions. It's now a matter of hours of legal work to move a transaction into a different jurisdiction. So it all comes down to the problem of cost. There is no free lunch. And if we want to ensure protection, if we want to insert safeguards into legislation, that means that there will be certain costs associated with those safeguards.
Well, I think we had about 20 laws on the protection of borrowers in hard currency coming from the members of parliament. For them, someone is supposed to pay those parties that never took those loans, banks or other parties. And this is quite in line with what Evgeny Sukhanov was saying about private title. If we preserve the titles in the shape that they exist now, we need to understand that this title will have a cost attached to it. And by adopting any regulation, we should think about it. We should think about how much it will cost and who is going to pay for all of this. This is competition. I would like to pay your attention once again, dear friends, that all of the people present here are participants of our business breakfast and participants of the discussion. And we have our helpers with microphones going around the room, and if you want to say something, please raise your hand. If you want to argue with one of our speakers or make a comment, I would like to ask Evgeny, if I understood you correctly, you said that today, I don't know whether it is a systemic problem or an institutional problem or territorial division problem. You said that we have a post-Soviet rudimentary tradition of creating zones or areas instead of what? We have a problem of taking decisions on very individual items, like those connected laws connected to Olympic Games and the championship, football championship of the world, and we change the laws of taking away land from people, and this order is very different from what is envisioned in the law. New Moscow is a great idea, but why should we confiscate law from people in some simplified mode? So we take those individual laws and we come across general problems all the time. If we said in our constitution that private property cannot tampered with, and we should stop that. We should not disturb private property by separate laws. We should not stop gaps by individual laws. Well, I don't want to go into the civil code very deeply, but the thing is that we have adopted it, and this is it. But 2 weeks later, we received certain amendments about, say, religious organizations, and those changes or amendments mean that they mostly are regulated by the law on religious organizations rather than the civil code. I'm not going to talk about a specific Orthodox or other denomination. Please do not take part in property turnover, but if we are involved in property turnover as a legal person, as a legal entity, you have to be acting on par with all the other participants of the market, without saying that you are religious, you are special, or whatever. So we made an exception, trying to make it out of good intentions. When you say we, who do you exactly mean? It's a very difficult question, because theoretically I should say the legislator, the State Duma, but I see an immense pressure there. I see a huge lobby there. The Council for Codification is a rather broad working group that includes judges, lawyers, independent people, but they have created a draft law on improving financial transactions, which will probably be adopted in autumn. For the first time, this draft law was submitted 3 years ago, and since then the Central Bank of Russia, the Association of Russian Banks have been working on this draft law. Those parties that are interested, rather than the customers of banks and other independent parties. And the State Duma, unfortunately, will vote for, because they are under huge pressure from lobbyists, but the processes there are very difficult. Lobbyist pressures were discussed yesterday at the meeting between President Putin and representatives of SMEs, and I think that you all heard about what President Putin said. Lobbyism should be made decent, should be made legal. Lobbyism shouldn't be understood as lobbying on the part of business circles. There is positive lobbyism as well. We have heard the voice of people who protected the rights of consumers. We would like to welcome those lobbyists, but there is another group of lobbyists. Thank you, Oksana, for your kind words about the civil code. We have established a new type of legal entity, Kazakh societies. Where do they come from? This is lobbyism on the part of the public authorities. We have these Cossack organizations, but why should we make it a separate type of entity? And the parliament had to do the way they were told by the authorities that be. Über Gemeinde von Kosaken, this is what I'm saying to my German friends. I'm ashamed of those legal regulations, but this is a result of lobbyism on the part of public authorities. Is there any counter-lobbyism? You want me to show all the hand that I have? We are very thankful to the Parliamentary Committee for Legislation, because the head of this committee, Pavel Krasheninnikov, was very active in the development of the first parts of the Civil Code. This can also be called lobbyism. We support this kind of lobbyism, and he supports this kind of lobbyism, but he is not God Almighty. The missing link in the chain. Konstantin Olifir, head of the legal department of Открытие company. Well, brief opening remarks, and then we will return to our discussion. Good morning. I'm sorry for being late. I hope that I haven't missed anything interesting. You want some welcoming remarks from me? Yes. About legal strategies at the time of turbulence. Everybody has to survive. Everyone has to sustain its competitive advantage. Every difficult situation is a kind of an opportunity in terms of optimizing our operational costs. We're changing our laws very positively, I think. We're using the opportunities that the negative economic situation creates for us. I would like to give you an example. If everything was great in our economy, we wouldn't be ever thinking about regulated foreign companies whose role is very important. We would never think about that. Therefore, I think we are clever enough to take advantage of this situation and extract additional competitive advantage from this. Dear experts, we've been talking a lot that we need to adapt, change our legislative or legal system, make it more competitive or whatever. Is there any existing example on this planet where those principles would be realized in an optimal way at the time of turbulence? Is there such a single example, or it will always be a compilation? I don't think such an ideal situation doesn't exist and cannot exist without with all those changes in legislation, globalization of law. There are also national specificities, results of cultural developments. What is more appropriate for us now? The most appropriate system for us is not German, it is a Russian system for us now. How about Cossacks? For England, the English system is the best. For Germany, the German system is the best. There are general institutions like the law, the contract of purchase. I would like to say a few words about the advantages of the English law. In the contractual sphere, we can discuss that, but in the field of property law, we don't have in England or America, there is no land title. Because William the Conqueror 1,000 years ago said that all the land belongs to the crown. Shall we borrow this kind of English law? And then let us create a government title to the land. This is absurd, but that's why the English law doesn't have anything to do with us, and the Russian law doesn't have anything to do with the English. We need to understand the idea of how they approach to it, but we need to enshrine it in our legislation and shape it accordingly. Thank you, Anatoly. I would agree with Evgeny. So the developments should be national, and we would like to borrow the best elements of many systems, and the English law, well, it has conquered the world and the minds for a rather long period of time, of businessmen, of lawyers. Anatoly, probably working in a different field, doesn't come across English law very often, but those who work in business, we have to deal with it every day. And many of those provisions of this law do not apply to Russian reality. And Yuri was very right when he said that if we do not borrow the best elements, the business will go to a different system. We have a group of very active Armenian entrepreneurs. Armenia, you know, is not a very rich country in terms of export possibilities, and there are initiatives to make it a law that English law is the dominating law in Armenia. Creativity is at a very high level, so we need to use this creativity to improve our legal systems. If all the transactions in Russia will be governed by Armenian law, I will queue to become an intern studying under Oksana's tutelage. You remember several years ago we had a confrontation, or a scandal even, with Great Britain, when a British politician said quite unequivocally, when we referred to our constitution and we refused to extradite Mr. Lugovoy, and he said, let them change the constitution. What kind of problem is that? Okay, let us continue and take a look. Although you correctly pointed out that any law has very clear national features. Let's take a look at Asia. Oksana Balayan, I think you are quite well versed in this area, and you can say a lot to us. Our turning to Asia in political and economic sense has been very significant. So it's for the benefit of myself. About the Asian topic, Vitalik is probably more knowledgeable, but what refers to all things legal, this is about what kind of law we're currently applying. Yes, we're turning towards Asia, although we all understand that transactions with Asian investors are very difficult. Their culture is very different from us. If we take the legal component, when we receive a document, a memorandum of understanding, whatever, with an Asian investor, with a Chinese, for example, investor, first of all, the Chinese law governs everything. For them, this is the starting point. As for us, the starting point was English law. Now it's becoming Russian law that is the starting point. What is Chinese law? Very few people have an understanding of that. You cannot read this law because the hieroglyphs are different from our letters. So all this area is an absolute terra incognita for us. But we're moving in this direction. Our law firms are opening their branches there. Our businesses are opening their branches in Beijing, in Shanghai. But we're not talking about just a legal turning to Asia. The problem is to which court to go. Before, everyone tried to go to English courts, but people are talking about arbitration procedures in Hong Kong. This has become a standard procedure that is envisioned in laws and in the contracts. So there are many interesting things happening in this field. I hope that at this forum we will have representatives of the Asian legal culture, and we will listen to them, and we will learn something about Asian law about which we don't know much at this point. I would like to make an amendment. We're not talking about turning to Asia. Russia is chairing BRICS this year. This means that we also pay attention to Argentina, India, and not only China. And since we are paying this attention to these countries, and this is not by accident, I think that those aspirations of ours are based on the understanding that in the big countries, and those are big countries, we have some legal ideology that we share. We are very different, but what do we share? All those big countries are truly sovereign. I'm not talking about the legal fictitious sovereignty, but understand that all the 186 or whatever countries, they are legally sovereign, but this is not a reality. This is some sort of fiction. But sovereign countries in the true sense of this word are not very numerous, and they should be recognized as nations. What are the determining features of the real sovereignty? I was trying to talk about that, and you interrupted me. It is when a people understands historically that as a entity, and it will not be subject to overarching universalization. Everything should be universal, should be different. And this is what our American colleagues are saying. The freedom word should be, the freedom of speech should be the same as in the US, but the Germans have their own idea of the freedom of speech or expression, and they think that private life is much more important than the freedom of speech. We are very different, and this legal identity should be an ideological basis for our economic cooperation. BRICS doesn't mean that this is a group of countries that are interested in one another. BRICS means traditions and culture and everything else.
Concerning Gadiz's words, we have already seen this happening. Some wise people in the middle of the 1990s put forward the idea of model laws for the CIS countries, and we have used model laws. For instance, we have had a model code for the CIS countries developed together with colleagues from Ukraine, Kyrgyzstan, Kazakhstan, Belarus, and other countries. At least 7 to 8 CIS countries, and doesn't matter whether the CIS is dead or alive, have very similar legislation, and we don't have any problems of dissimilarity of laws as with China, even though they have their own civil codes, their own laws, but there is a common legal framework. As part of the Eurasian Economic Community, we have started developing the foundations for civil legislation of this community, and I think as part of BRICS we could also entertain this idea of developing common legal approaches or frameworks for the BRICS countries, of course without any detriment to each country's national systems. Okay, we started by talking about this Asian vector, and now we're talking about BRICS, but what about that Asian reorientation and where it's leading us? Again, I'm trying to provoke you a little bit here. Why is it happening? Is it because of despair, or is it a viable opportunity indeed? Because, look, Oksana said about the difficulties. It's difficult to talk to them. It's difficult to communicate. They have a different writing system. A lot of challenges here. I think I will take some 30 seconds to reply to this. China is not a terra incognita to us. We go a long way back, and I have traveled to Beijing several times and talked to colleagues there. It wasn't until several years ago that they have started themselves to codify their civil legislation. They have certain foundations for that. They have a Supreme Court plenary decision that regulates a lot of civil law aspects in China. And they still keep coming to us as students. I've had Chinese students in law school, so we have certain cooperation traditions with them. And interestingly enough, Chinese law as well as Japanese law is very much founded on German law. So this Asian orientation is for some objective reasons, but Russia has always, like that double-headed eagle, has been looking towards both directions, and China is a very important part of the world. It's going forward very actively. Why should we be limiting our cooperation to the US, Germany, and Europe? Why shouldn't we be working with China? And if we are to work with them, we should codify our relations legally. China is part of the Vienna Convention, although it's not doing a good job implementing arbitration decisions, but that's another problem altogether. I think I will be the bad cop here, because in my opinion, we are confusing two things. It's one thing to maintain political and economic cooperation, but it's quite another thing to try to compete in the legal field. And we should be very sober about that, really. It seems to me that both former Soviet republics and the BRIC countries are competing against us very seriously for the same benefits, for the same economic advantages. Therefore, when we work with our neighbors, we should certainly be borrowing the best practices from them. We should be learning from the experience of the strongest and the most powerful. But generally speaking, when we develop our legislation today, we shouldn't be trying to bring it closer to one economic partner or another, because our economic partners may include countries that are completely dissimilar to us. And there are always ways and strategies that businessmen will use in order to resolve conflict situations and to structure their deals in the most appropriate ways. I don't think we should be overburdening our law and our legal system by trying to establish similarities. And some of the colleagues mentioned that already. Yes, indeed, a lot of large contracts will inevitably be governed by non-CIS law, non-Chinese law, non-Indian laws. They will be taken to the English jurisdiction or to other Western jurisdictions. The immediate objective that we can formulate for ourselves would be to establish very clear and predictable legal mechanisms in our legislation that would be recognized by the rest of the countries, trying not to safeguard any of the pseudo-interests that we mentioned. Let's try to bring back to the Russian jurisdiction at least those Russian businessmen who initially preferred to work with us. What about small, medium-sized businesses? What about some of the CIS businesses? And that in any contracts there will still be references to international arbitration, no question about it. But if a factory is bought somewhere in a province of Russia, we shouldn't be taking that person to Stockholm arbitration or to any other overseas arbitration if they don't even speak English well enough. Why not make our jurisdiction more competitive? Okay, Yuri, as a representative of the Ministry of Justice, the most important mechanism here is international commercial arbitrage, and as a representative of our arbitration, I can ask this question. Which country has consistently turned down international arbitration decisions over the past year? It's Russia. Russia has been doing it time and again. It's only the Constitutional Court that has critiqued and criticized this practice just recently. You know, people, jurisdiction, are afraid of our arbitration practices. About 20 or 25 years ago, when I was an arbiter in Stockholm, it so happened, for technical reasons, that two arbiters signed a judgment, but two other arbiters signed a different text of the judgment. But there were no three arbiters that would sign the same text. In our practice, in our system, the court would simply cancel the decision, whereas the Stockholm City Court upheld the decision. And I remember testifying in Stockholm City Court. And it became evident that there were three arbiters at least who agreed on the same judgment terms. That's why people keep going to Stockholm and London, because they know that in Russia our courts will revoke decisions quite arbitrarily. Currently, third-party courts are being discussed in Russia. My colleague could clarify that. Yes, I became very interested in that because my understanding of competition is that competition encompasses not only competition with other countries' legal systems, but also inside the country. And in my opinion, this type of litigation is a very important way of encouraging and promoting litigation in my country. You remember I talked about legal courage and judiciary courage. We all know that this is a problem. I think that this type of arbitration court or intermediate court of arbitration would be a very important mechanism to increase our judges' boldness. And boldness and courage is a very important ethical category for our judges. It's no less important than the judges' knowledge, experience and expertise. Unfortunately, our judges are not courageous enough. Would you like to share something with the rest? Because you mentioned members of parliament. Okay, I'm not going to quote you publicly. Yes, courageous judges. This is a difficult to formalize, but no less important category. How do we educate courageous judges? Famous Russian journalist Vladimir Posner said the other day, I don't know if you agree with him or not, he said that Russia doesn't have journalism, it only has some journalists. Vitaly, this is also your field, because it also has to do with the Chinese orientation. Not really. Well, I guess I was invited here to specifically discuss this Chinese reorientation. I have a legal background and a degree in law, but I have never practiced law. So this conversation is about familiar terms, but I'm not a practitioner. As a representative of the Union of Industrialists and Entrepreneurs, I see my priority as working with local administration and local authorities trying to promote investments and the creation of Russian, Asian, Russian, Chinese joint ventures in the Russian Federation. So my primary objective is to attract investors from Asia into Russia. As far as Chinese legislation is concerned, quite a lot of major companies, some of which are represented here today, come to us. Because what happens to them, they sign an agreement, they go on various events or missions together with the Russian president to China. As a result of that, they generate agreements and contracts, but then they come back to us and start asking questions. They ask, where do we go from here? We don't know how to work with Chinese partners. Could you please explain to us how it works with them? What's in the back of their minds? What's the main problem with Chinese partners? Well, it's the difference in mentalities, mainly. And how does it manifest itself? They view life differently. I mean, it's like a different planet. But how does it work in reality? Are they being too Confucian or what? Oh, let me give you a very simple example here that Vladimir Putin referred to recently. We spent a lot of time till 3 a.m. discussing and negotiating. We went to bed, we came back in the morning, and we had to start from scratch again. That's the mode of working that they use. Because we believe that if we have reached a certain point, we then take it from there. But with the Chinese people, it's different. You get back, and they tell you, you misunderstood it, let's start from zero. So this is something to remember. Every single achievement, every single agreement needs to be documented with your Chinese partners. You should always keep minutes and record everything in your minutes so that you can refer to it later. Oh, this is very intriguing indeed. So you need to put in writing every single word. Do you think this is a ploy that our Chinese strategy use, or is it because it's a very unclear situation with Russian partners? No, this is their way of living, and the Russians will take offense very often, because what we say is, look, our Chinese friends, we have come to a certain agreement with you. We have discussed this. Maybe you address them in an improper, non-Chinese way. Well, of course we address them properly. There are many people with whom I have rather brotherly relations. They have this word, gömmer, brother, right? That's a good word, right? But please understand, they are different. For instance, it's unfathomable for them to be able to sit down, negotiate, and sign an agreement in just 5 minutes. And sometimes it happens that we have discussed and negotiated everything. We come back to sign the agreement. We spend 15 minutes sipping tea. Then we spend some more time talking. And then about 2 hours later, that's when we start talking Turkey. That's how they work. That's how they approach it. And this is something we need to understand. Sometimes we start negotiating with some Asian partners, and my client, the company, whispers me in the ear, look brother, what about those Chinese? I don't like Chinese. And you know, at this point I say to the client, well, if you don't like them, if you don't respect your partners, then why come here? Why negotiate with them? So I think it all starts with having respect for your potential partner, and in that case, chances are that it will work. Thank you very much, Vitaly. It so happens that we have the head of the Arbitration Court of Hong Kong in this room, and I would ask Mr. Chairman to make a brief intervention, maybe, to share with us the perspectives, right? Please. Yeah, please.
Hi, good morning, everybody. I'm from the Hong Kong International Arbitration Center.
Вы помните, да, у вас у всех есть пятый или шестой канал?
Sorry, I can't speak in Russian. So it's been a very interesting discussion that everybody has been enjoying this morning. We do find more and more Russian parties are transacting with Chinese colleagues, but also other Asian businesses, and looking for places where they might like to have their dispute resolution seated, and often that will be Hong Kong. So we do have excellent experience in dealing with both Chinese and with Russian and other Asian businesses in terms of our dispute resolution capability. I'm not sure what specifics you're interested in, but obviously we are very happy to be here in Russia and to take part in these kinds of discussions that you're having this morning. Thank you.
Спасибо большое.
Thank you very much. All right. Since we got on the topic of differences between jurisdictions and best practices internationally, we have been joined by Konstantin Olivier, who was the last person to join us today. So let's talk about this. Again, this is a kind of reorientation, maybe not exactly reorientation, but there's this thing, Islamic banking. What about that? Is there any food for discussion here? Well, Islamic banking does have potential in Russia, certainly. Unfortunately, I'm too detached from that topic, really. I know that certain transactions have been undertaken under that framework. I'm sure that Tatarstan is going to lead the process. Unfortunately, we don't work with such transactions. I don't think they're going to be vastly competitive with the majority. And what else would you like to talk about? I just wanted to go back to the different elements that we can borrow from the legal systems of various countries, including BRICS. When we make a transaction with Chinese partners, they do not voluntarily choose their Chinese jurisdiction to govern the deal. It's something that is imposed by the state. It's a requirement imposed by the government for all international deals. It's part of the Chinese government's policy. So going back to potentially borrowable elements, we could apply the same approach to Russian jurisdiction. Again, I think we're still being too shy about this. Sometimes we're too modest to say that we have a pretty good legal system that can be used to govern in a mandatory manner various transactions. Something funny happened to me about 3 years ago, some 4 years ago, when we were developing the market for derivatives here. And there was a new provision introduced into the tax code, and that provision, it so happened, contains an error that only applied tax deductions to derivatives used under Russian legislation. If this was the case of a foreign jurisdiction, there was no tax exemption, which created a significant competitive advantage for derivatives under Russian law, and it was a ridiculous mistake indeed.
Well, there are many other mistakes in the tax code, but the result of all of them was that in a couple of years I saw that an increase of tenfold or fivefold increase in derivative transactions that were governed by Russian law. This is just an example. Why don't we use those occasional errors even to impose Russian law? Why our companies continue to enter into transactions governed by international law, by foreign law? We are being modest. The Chinese are not modest. They force their companies to enter into transactions under Chinese law, and we think, well, you know, English law is so great. Maybe we're not too modest. There are other factors that force us to act in this way or not in another way. I think that Russian law must be promoted as part of public policy. We have to force Russian companies, especially those with government participation, to enter into transactions governed by Russian law. I'm not going to offend our foreign colleagues, Oksana, I'm sorry for this, but if Russia wants to have its sovereignty intact, if we want to be a sovereign country in the full sense of the word, we can do. Well, The word force is not something that scares me. It's one of my favorite words. So, Oksana, maybe you think something about, as a foreign colleague of ours, about forcing companies to do this or that. I am a Russian lawyer, an English lawyer, and I defended my thesis in Germany. So I think Konstantin meant that I represent a foreign legal company, and mainly international legal firms use English law or Chinese law. Here we may make a considerable contribution for the transaction to take place. Konstantin was saying about the need to promote Russian law. I think it is being done right now. When we talk about transactions involving companies with government participation, they more and more are involved in checking whether it is possible to do according to the Russian law. But in some areas we are lacking something. But if there is this trend, no one is going to improve the legislation. If we take into account that the Russian law is not appropriate, we just take another legal system. Well, I think that is there such a message that we should promote Russian law? Yes, it exists, but it is weak. But how can we make it stronger? I've given you an example of the tax code. We have a new tax code makes room for many more Russian transactions being carried out or governed by the Russian law. Russian assets should be bought and sold according to the Russian law. Those are technical things that can be done, and gradually make so that transactions are carried out under Russian law. We should understand that some time ago, when everybody used English law, all our partners worked in accordance with the English law. Well, I'm talking about 1996, when the Civil Code was first adopted in Russia, and a huge amount of intellectual resources, lawyers I mean, they thought about how to work under English law rather than thinking about how to develop Russian law. Of course, if you do not use a system of law, it is not going to develop. You can force people in different ways to use it. There should be no discrimination, but at the level of government, companies, in what refers to Russian assets or intellectual rights, everything is there. We just need to improve the legislation, of course. Well, there are lots of acts related to foreign companies which we borrowed from our international partners. This is a very interesting concept, and everybody is thinking how to evade this law. But I think that the Ministry of Justice and other ministries will make sure that holding companies will return to Russia. This is another way of how we can exert soft influence to use best international practices of tax planning, so that the companies could return to Russia within the Russian jurisdiction. Well, I fully agree with Konstantin. You cannot but support the idea that there is a need to force, in a good sense of this word, to impose Russian law. What is the main problem that I would like to highlight in this regard? The worse the product is, the more difficult it is to impose it on someone. So that well, in order to be able to impose Russian law on government-owned companies, you need to make sure that Russian law is competitive. It is, well, appropriate to carry out this and that transaction. You can make certain minor changes, even if the product is rotten, but you cannot impose it on anyone. You cannot force anyone to buy it, and there are good changes that we have seen. We have to strictly follow those positive changes in our law. I would like to say a few words myself. There is another very deep aspect, a very important aspect from my standpoint. I'm talking now in my hat of a professor of a university professor. Our financial people and lawyers, they have been educated in accordance with American law. When they say law, they mean American law and nothing else. And our graduates of faculties of business and economy, well, we were, well, deputy head of a department of corporate development was returned to our university, and we fought with him for 10 years. When he hears the word corporation, it means for him an American corporation and nothing else. Because in 1990, the Soviet textbooks or manuals were burned, and they translated American manuals in economics. Let us return capital from offshores. They wanted to introduce irrevocable trust. This is the first thing, well, for the first time I heard this concept from the Ministry of Finance. Irrevocable trust. We're talking about bringing up our students. We're trying to bring up our students in a normal and good way, and we produce quite good lawyers. Well, economists should also be trained based on Russian law, because initially their brains are geared in a different direction. Okay, let us forget about good manners. This is a discussion, an open discussion. Or are you going to say something according to? My name is Alexei, I'm from Hohenlohes. I would like to make a brief comment with regard to a number of statements made here. And it also refers to the turbulence that we've been talking about. Good manners here means to criticize everything, and first of all the government. And I think that some issues are underestimated, meaning how the government influences government-owned companies. Other people say that the government should not influence companies at all. In my area of arbitration, I would like to specify a number of things. Number one is sanctions. As far as we know, government companies have been tacitly instructed to choose jurisdiction and arbitration in those countries which introduce sanctions against the Russian Federation. This is not an instruction as such, it's a recommendation rather. But as a result, people may reorient themselves and enter into contracts governed by Asian arbitration courts. And companies tell us, please help us. The companies are asking the government, give us arguments. How can we convince our partners that we should go to arbitration, not in London, not in Stockholm, but in Hong Kong or elsewhere? This is a rather rational approach. And I would like to say that today, during the time that we see a lot of bankruptcies on the part of banks and companies, A lot of issues arise with regard to assets seized abroad. Assets that have been transferred abroad and they are now seized, and the agency for deposits safeguards acts as a temporary management company for many banks that have gone under. And many people say that English law courts are more effective than Russian courts because progress may be achieved faster than when you deal with Russian courts of law. And this is something that was identified by a Russian bureaucrat, because they have a certain independence, they have a certain quality standard. But by saying this, I should also say that there are cases that are viewed by the legal community as controversial. The Yukos case, for example, how it was decided and this creates a very complicated landscape. There are sanctions, there are different legal centers that compete with one another. There are issues related to government policy, because every jurisdiction is trying to maximize disputes that are dealt within this jurisdiction. I would like to forewarn you about oversimplifying your approach to the situation. Well, the situation is quite complex and dynamic, and for us practicing lawyers, of course, in every individual case, we need to understand all the risks involved, all the operational opportunities that the transaction gives us, the need to protect the interests of our partners or clients or whoever. So the world is not black and white anymore. We need to individually and thoroughly analyze each and every situation, and the Russian law is not very bad from that standpoint. Yuri, please, you have the floor. Thank you. I would like to point out two things. Right now, it is an ideal situation to enhance Russian jurisdiction, because in many other traditional jurisdictions, things are not all that bright. We are developing very dynamically, and we are quite a flexible jurisdiction on the other hand. When we had a forum in France and we sat side by side with our French colleagues and we discussed their tax system, they cannot believe that we have a flat tax rate of 13%, which can be reduced in some cases to 6% or to some fixed payment. Our banking system is much more flexible. We don't have so many compliance requirements. We have a lot of advantages as a developing system, which is flexible for that reason. We are not burdened by social or other obligations which have traditionally existed in other jurisdictions. So what shall we move away from in terms of what should we get rid of before we can impose Russian law on Russian companies even? Well, I would like to give the name of the document of my favorite Ministry of the Economy. It is not the worst regulator whose documents we can get access to. I would like to apologize before foreigners, because I doubt that our translators, our interpreters will be able to interpret it, but maybe you will understand. This is a document dated the 31st of December 2013, so which is not by chance. By the new year, they tend to develop lots of legislation. Document. This is the document on the title holder to property about the registration of documents if the cadastral registration of a specific type of property is not carried out, or that in the case of transfer of title to real estate, on notifying about property, real estate transactions and registration of the same, notifications of decisions by courts that have entered into force in the case of registering the transaction which was identified as not being valid, notification on making changes to the unified register of titles to real estate. I'm close to finish this reading on the registration of the title to real estate in a territorial authority of the Russian Federation. What can we impose this thing on? The lawyers are not talking in this language between themselves. Well, I just recorded it. Well, this is not the only document in my collection. I have dozens of them with such titles. While we have this, what do you mean? What is the systemic problems? If a document has a title like that, you can understand what is in it, what the content of this document is all about. You are saying that this is a problem. While we have this, nothing good will come out of it. Well, the quality of regulatory documents. It's difficult to find a decent word to describe it. It's not just a problem of the human factor, it's the problem of organizing the work of the government administration. This has been many times discussed at various fora, and everything is going from top down in the government. Everybody is acting on instructions from the above, and then in order to close the year plan by the 31st of December, they will create this document.
But this is also an influence of American law. For instance, you all know about how transactions with an interest are formulated. I remember the first draft that was proposed to us, there were sentences there that were 5 pages long. Sentences you could not really understand without reading them 5 times. And the mere definitions were 1 page worth. So very often we get bills and laws with a lot of lengthy formulas and wordings that you cannot really work with, but this comes from American law. I mean, for instance, if you take these transactions involving interested parties, again, did we really need it? And now that they have adopted it and currently amending it, I mean, the Ministry of Economic Development, hopefully they will improve that document. You know, this legal gobbledygook is really something that we have borrowed from American law. The economists should not be part of formulating the wording. They should only provide their input. I remember one official told me several years ago he had to work with about 50 legal documents a week, and his legal department was the largest, possibly among all the other line ministries, and he had a bevy of young girls, economics law students working for him. So what happened was, during the day they worked with the legal documents, spending a lot of time on them. In the evening they went to their classes, and he invited me to lecture them on some aspects of law, because he wanted help from them. He could not cope with all that legal paperwork himself. So generally I would say it's up to the Ministry of Justice to deal with the wordings. But you know, the amendments that are currently being introduced to the Civil Code, they are usually taken through a lot of offices and a lot of experts, so the resulting quality is usually quite high these days. Yes, there are controversial provisions there, but it's much better than many other federal laws that I have seen, and I think we need to thank the Ministry of Justice for promoting this reform. It's too early to say thanks because we still have another 30 minutes to go. May I intervene? Well, I think we should thank Gadis Gaji for participating in this discussion, and please continue. On behalf of the businesses, Russian businesses and Asian businesses, I would like to say that it is certainly a welcome fact that such discussions happen around how to improve legislation, how to address problems in the legislation. And it's certainly important to have high-quality legal products, but another issue is how it is to be implemented. Should it be imposed on our businesses or not? Should government-owned corporations operate under Russian legislation? What happens today is this. Russia adopted a law. I don't remember the exact title or name of the law, but this was a law according to which top management in government-owned corporations was obliged to present all their income and profit statements to the government authorities. I mean, that was basically the principle, and everybody said, yes, of course, these are government businesses we're talking about. They should be reporting their incomes and their costs to the state. But then there was this guy that said that it's an intrusion and it's interference with corporate secrecy, and that corporation said, we're not going to report. In response, the government said that maybe not. On second thoughts, this doesn't seem like a very good law. Perhaps we shouldn't require top managers of state corporations to report in this way. Then there was another policy initiative to fight offshores, and everybody was supporting this idea to get rid of offshores. But then there was another state corporation that said, we only work through offshores, we can't do it in any other way. And that's the whole idea, you see. I'm very much in favor of the government policy, and I fully support Russia's policy with respect to the Asian countries, and I fully support the idea of my colleagues when they say that we should be operating under Russian law. And I certainly share the opinion that we shouldn't be looking up to the foreigners and trying to learn from them, because they are by definition better. Yes, this is an excellent idea, but if we were to adopt a set of rules or laws, we should then be consistent in abiding them and not violating them. And it seems from my example that there are a lot of inconsistencies in application happening in this country, and people keep coming to me every day asking, why is it that we have such a difficult situation here in Russia? Where do we put our money? Where do we dispatch our savings? To which country of the world? even though these are companies and people who need a lot of operating capital these days because of the constrained economic situation, because of the lack of liquidity. Who are you addressing when you say this? I'm addressing my colleagues who are responsible for developing and implementing Russian legislation. And that also has to do with Mr. Judge Gajiev's words about judiciary courage, right? Yeah, and another fact about judiciary is, take the UCOS case, for instance. Our commercial arbitration under the Chamber made several rulings with respect to that case, and those were quite regular and quite substantiated, but they were invalidated by the Russian government. Again, we may have high-quality private arbitration and other arbitration mechanisms. It may be that our arbitration courts are quite competitive before Hong Kong and Stockholm. For instance, we have this Moscow Arbitration Court under the Chamber of Trade and Commerce in Moscow that has worked for 80 years already. 50% of our arbiters are people from abroad. So they're performing very well, and it's less costly. I mean, if you ever arbitrated in London, you know, because I have. The late Boris Berezovsky had some litigation in London for the first time, and when he had to pay litigation costs, he said no to English litigation immediately. So in Moscow it's easier, it's faster to arbitrate than in Hong Kong or in any other places. The only danger that exists here is that whatever ruling is made, it can be completely invalidated by the Russian authorities. So rather than creating an international financial center of Moscow, why don't we try to create an international litigation arbitration center in this country? Well, just as a colleague said, the main competitive advantage of a jurisdiction lies in its stability and predictability. Dear colleagues, we don't have 30 minutes. As I said previously, I have to correct myself, it's only 15 minutes, but we can certainly welcome questions from the floor or whatever interventions you may have. Please introduce yourself. Yevgeny Pisovetsky, Social Insurance Foundation Fund of the Russian Federation. I would like to offer my comments and my opinion regarding strategizing and business strategies and national strategy in times of turbulence in general. From what I heard, I realized that you see turbulence as a threat, jeopardizing Russia's national interests. If that is the case, then it's one strategy. Let me give you an example. We keep talking about nature and the world of nature. Consillier, a physiologist, developed a theory of stress comprising 3 stages: avoiding, reneging, stress, and finally opposition and fighting the stress factor. Avoidance. In terms of strategy, avoidance means that we keep our legal system as it is, regardless these factors of turbulence. We just continue in the same pattern. Flight. The flight phase, in this case, in terms of our strategy, would be to succumb to foreign legal frameworks and provisions, primarily Anglo-Saxon frameworks, and finally active fight. That would mean, in terms of strategy, deciding not to accept any foreign influence and trying to develop our own strategy. But of course, a strategy of this kind would not be very productive. While I was listening to this presentation, I also looked up the dictionary for the word turbulence, and I learned that animals are very good at dealing with turbulence. Some animals, for instance, can use the power of headwinds to their advantage. And this brings us back to what Judge Gadzhiev said. We should use the potential of law, including the exquisite nature of law. And in practical terms, that would mean devising adequate legal policy measures and implementing them. I think we shouldn't really have any codified document on the legal development policy, but I think we should have 10 central principles that would be implementable and would be part of the government's policy agenda. These written or unwritten policy principles towards legal development should be encompassing, they should be cross-cutting and should be taken into account in all aspects of economic life and in other fields. If we could achieve this kind of unification on an overarching framework of principles, it would be a good start and the economic activity would be boosted as a result. Thank you very much. This is a very interesting intervention. Unless we have any other lengthy interventions, we are going to wrap up this discussion. Do we have any further questions? In the absence of questions, I think I'm going to do a little bit of entertaining for our panelists and for the public. And I would like to ask a funny question. You know, funny questions are good in that they are usually thought-provoking. And I think you have understood by now that I'm not a legal person, quite the contrary. I'm just a journalist. You keep using this phrase, and I think I understand it, but you know, I don't think I'm very knowledgeable about the nuts and bolts of it. You have been mentioning Anglo-Saxon law in particular, and other types of law. So do I understand it correctly that there is a set of documents or a body of materials that constitutes that legal tradition? Do we have a similar body of acts or documents that would amount to the Russian legal tradition? I mean, you're looking at me as if I were crazy, but still the question remains. Well, there is only one legal tradition that we have that is completely indigenous. It's an advance deposit or advance payment that dates back to 16th century Moscow. You know, it so happened that since the late 18th, early 19th century, Russian law has developed on the basis of German law, and the same goes for our education system. You know, even our educational formats and curricula were copied from the German system, and it's hard to change now. We're very, very entrenched in that. The notion of property only emerged very, very late. So we are so much immersed in the German tradition. It's ingrained in us. And again, think back to the times when Christianity was brought to Russia. Prince Vladimir could have chosen any other religion, but he chose Eastern Christianity. So, and had he chosen something else, we would be talking about Islamic banking today, right? I really welcome the fact that we have a moderator who is not a legal person, because he has been asking some pointed questions here. Anglo-Saxon law may sound like a mouthful, but what it basically means is this is a legal tradition of a certain set of countries. Russian law, well, it's something that works for Russia. It's not a set of materials, it's a tradition and it's a living thing. I'm sorry. Konstantin proposes to name it Great Russian Law. Yeah, we have been borrowing a lot. We are borrowing a lot of elements while preparing our civil code. Should we ask Yuri to read the name of that ministerial circular once again, just for the sake of entertainment? And I still remember some of the Zaum early 20th century modernist literature. They used to speak in that kind of language, and sometimes it reminds you of poetry, right? Or white verse. All right. To conclude, dear guests, I hope that we have at least partially satisfied your interest in this topic, strategizing in times of turbulence, and this was basically the title of this business breakfast organized and hosted by Kommersant as part of the St. Petersburg International Legal Forum. I thank you for your attention, and I would now invite the panelists to make a few concluding remarks. As a quick announcement, tomorrow we have another roundtable as part of the 5th International Legal Forum, and you're going to like the title very much, especially Mr. Lubimov. Exterritorial application of national laws and the risks arising for transnational companies. This is scheduled for 10 o'clock in the morning tomorrow. And now, colleagues, please try to wrap up in the best possible way with maximum brevity your statements. Yeah, thank you very much. All I have to say in conclusion is that when it's turbulence, they don't give you food on the plane. And I guess I want to wish you a very productive, interesting, engaging and stimulating forum. Just to continue on this discussion, people shouldn't be imposed or restrained. People will act and people will grow and develop if the rules are clear. I think the state should be encouraging self-development and growth. Oksana? I would like to thank you all, and I wish you a very good forum. I think that at the end of the day there should be a very clear and consistent government policy for the development of the nation that should span several decades ahead. And if that is in place, I'm sure we will lead the way for the rest of the world. Thank you for your discussion, and I wish you a good forum. Konstantin? Yeah, I wish you a great forum indeed. And once again, to reiterate, any challenge also means opportunities, and hopefully we now understand this and we're mature enough to use these opportunities. Yes, please.
Пока мы попрощаемся. Вадим Зарипов, компания.
Vadim Zaripov, I represent a legal firm. Honorable Judge has left us, but he said something that's very important, and I think we should support this very, very strongly in the 3 days of the forum. What's the idea? What's the message? Well, the message, as I understand it, is that investing into legal development is hundreds of times more effective in terms of return of investment than any investments in the economy. The government is funneling a lot of money into countering the crisis, but if we only invested in independent and impartial courts, into high-quality education and into supporting science and research, we would derive much greater return on these investments, and it would turn the situation around. It wouldn't change anything in the short term, but in the long term it's going to be much more effective. Just one small correction. This roundtable tomorrow is happening in room number 2 at 10 o'clock. It's on the 2nd floor, and we will be talking about exterritorial risks of transnational companies. Well, thank you very much. We have been skirting around this metaphor of planes and the fear of flying. I remember flying in Turbulence, and I remember spilling tomato juice on myself, and I remember Lufthansa rewarded me with a nice gift. That's all I remember. Thank you very much.